I'd like Miss Yasmin Sooka to please come to the stage. Yasmin Sooka, she's Chair, UN Commission on Human Rights in South Sudan and Executive Director of Truth and Justice Project. I'd also kindly like to ask Dr. Carlos Castrasena Fernandez to kindly come to the stage.
এখন শোনা যায়? ওকে, সবাইকে স্বাগতম। আজকে আমরা এই আলোচনা আয়োজন করেছি ব্লাস্ট এবং সেলস সাউথ এশিয়ান ইনস্টিটিউট অফ অ্যাডভান্স লিগাল অ্যান্ড হিউম্যান রাইটস স্টাডিজের পক্ষে। আমাদের আলোচনার সূত্রপাত এখানে হচ্ছে আমরা একটা সিরিজ অফ আলোচনা করতে চাচ্ছি ক্রান্তিকালীন ন্যায় বিচার বা ক্রান্তিকালীন সুবিচার অথবা ট্রানজিশনাল জাস্টিস নিয়ে। এই আলোচনাগুলো হয়তো আমাদের আরও 4-5 মাস আগে শুরু করা উচিত, যখন আমরা একটা ক্রান্তিকালীন পরিস্থিতির মধ্যে বা অবস্থার মধ্যেই চলে আসলাম 5 তারিখের পট পরিবর্তনের পরে এবং জুলাইয়ের আন্দোলনের পরবর্তী সময়ে। কিন্তু যাই হোক, বেটার লেট দ্যান নেভার। আমরা আশা করছি যে আজকের আলোচনা আমাদেরকে অনেক বিষয়বস্তু দিবে আমাদের নিজেদের আলোচনা এবং কীভাবে আমরা এগিয়ে যাচ্ছি আমাদের নিজেদের দিক নির্ধারণ করার ক্ষেত্রে। আমাদের আজকের এই অধিবেশনে দুজনই আলোচনা করবেন। একজন হচ্ছেন ইয়াসমিন সুকা, উনি আইনজীবী এবং উনি দক্ষিণ আফ্রিকার যখন তাদের ট্রুথ অ্যান্ড রেকনসিলিয়েশন কমিশন হলো apartheid ইরা শেষ হওয়ার পরে, নেলসন ম্যান্ডেলা যখন জেল থেকে বেরিয়ে আসলেন, নতুন একটা যাত্রা সাউথ আফ্রিকা যখন শুরু করলো, তখন তারা অনেক ধরনের আলোচনার মধ্যে দিয়ে গেল যে আসলে তারা কিভাবে যারা apartheid চালিয়েছিল এত বছর ধরে, সেই পুরো কাঠামোটা যারা ধরে রেখেছিল তাদেরকে কিভাবে জবাবদিহিতার মধ্যে আনবে এবং একই সাথে সমাজকে এগিয়ে নিয়ে যাবে। সেই কঠিন কাজ সেই সময় যারা করেছিলেন তার মধ্যে ইয়াসমিন সুকা অন্যতম, এবং তিনি তখনকার এই ট্রুথ অ্যান্ড রেকনসিলিয়েশন কমিশনের সদস্য ছিলেন। পরবর্তীতে উনি অন্য একটা দেশে সিয়েরা লিওন, তারাও যখন যুদ্ধ পরবর্তী অবস্থা একটা প্রক্রিয়ার মধ্যে গেল, ট্রুথ অ্যান্ড রেকনসিলিয়েশন কমিশন গঠন করলো, সেখানে উনি অংশগ্রহণ করেছেন। আচ্ছা, আমি একটু অনুরোধ করব যারা মোবাইলে কথা বলছেন, আমাদের যারা কলিগরা, প্লিজ ওনাদেরকে একটু হেল্প করেন বাইরে গিয়ে ওনাদের ফোন কলগুলো করতে, আর প্লিজ ফোনগুলো সাইলেন্ট করে দেন। সবাই কাইন্ডলি একটু সাইলেন্ট করে দেন আপনাদের ফোন। কারো অত্যন্ত জরুরি ফোন আসলে নিশ্চয়ই বাইরে যেতে পারেন। পেছনে এখনো একজন কথা বলছেন, একটু প্লিজ বাইরে চলে যান ফোন করার জন্য। পেছনে রাস্তা আছে, দরজা খোলা, প্লিজ বাইরে চলে যান ফোন করার জন্য। এদিকেও একটা গেট আছে। সো ইয়াসমিনের আরেকটু পরিচয় দিতে চাই। এরপরে উনি সাউথ আফ্রিকা, সিয়েরা লিওন তাও আমাদের থেকে অনেক দূরে। উনি শ্রীলঙ্কায় যখন যুদ্ধ পরবর্তী অবস্থা এবং সেখানে যখন যুদ্ধ অপরাধ তদন্ত করার জন্য একটা উদ্যোগ নেওয়া হলো জাতিসংঘের পক্ষ থেকে, সেই প্রক্রিয়ার সাথে উনি যুক্ত ছিলেন এবং এখনো উনি জাতিসংঘের হয়ে উনি সাউথ সুদান, দক্ষিণ সুদানের উপরে যে একটি তদন্ত করার একটা প্রক্রিয়া যে দাঁড় করানো হয়েছে, কমিশন অফ ইনকোয়ারি বা তদন্ত কমিশন, সেটার সভাপতিত্ব উনি করছেন। So you know your own bio, so I'm not going to say it in English again. আমাদের এখানে আই থিঙ্ক কেউ নাই যাদের ইংরেজি অনুবাদ লাগবে। কেউ কি আছে? যদি হাত উঠান বুঝে নিতে পারবো। ওকে, আমাদের দ্বিতীয় বক্তা হচ্ছেন ডক্টর কার্লোস কাস্ট্রাসেনা ফার্নান্ডেজ। উনিও আইনজীবী এবং উনি শুধু আইনজীবী না, উনি বিচারপতিও ছিলেন, ইনভেস্টিগেটিং জাজ ছিলেন, প্রসিকিউটরও ছিলেন, ম্যাজিস্ট্রেটও ছিলেন এবং উনিও ঠিক এরকম বিভিন্ন কমিশনের সাথে জড়িত ছিলেন। আমাদের আজকের সভাপতি চলে এসেছেন ডক্টর শামসুল বারি। উনি গুয়াটামালাতে ওখানেও যুদ্ধ পরবর্তী অবস্থায় যখন দায় মুক্তির কী কী হয়েছে, দায় মুক্তির ব্যাপারে সেগুলো উদ্ঘাটন করার জন্য যখন একটি কমিশন দাঁড় করানো হয়, আন্তর্জাতিক কমিশন, সেটাতে উনি কমিশনার ছিলেন। এবং উনি এখন উনি সাউথ সুদান কমিশনের মধ্যে আছেন, এবং আরও খুব আমাদের জন্য খুব প্রাসঙ্গিক একটা কাজের মধ্যে উনি এখন আছেন কলম্বিয়াতে। ওদেরও যুদ্ধ পরবর্তী অবস্থায়, ওদের আভ্যন্তরীণ যে যুদ্ধ চলছিল বা সংঘাতমূলক যে অবস্থা ছিল, সেখানে যে একটা বিশেষ উদ্যোগ এখন নেওয়া হয়েছে শান্তি স্থাপন করার জন্যে, সেই প্রক্রিয়ার সাথে উনি যুক্ত আছেন। সো ওনার এবং আমাদের আজকের সভাপতি ডক্টর শামসুল বারি, উনিও আইনজীবী। আমাদের তিনজনই আজকের বক্তা, তিনজনই আইনজীবী। উনি আন্তর্জাতিক আইনের বিশেষজ্ঞ, এবং উনি UNHCR এর খুব গুরু দায়িত্ব পালন করেছেন অনেক দেশে অনেক বছর ধরে। তারপরে উনিও জাতিসংঘের এই মানবাধিকার বিভিন্ন তদন্ত প্রক্রিয়ার সাথে জড়িত ছিলেন, এবং উনিও একটি কমিশন অফ ইনকোয়ারির চেয়ার করেছিলেন এর মধ্যে। এখন অবশ্যই উনি আমাদের সাথে খুব ওতপ্রোতভাবে জড়িত, ব্লাস্টের আমাদের ভাইস চেয়ার হিসেবে আছেন, এবং সেলসেরও উনি বোর্ড অফ ট্রাস্টিজে আছেন। সো আজকের আলোচনা শুরু করার আগে আমি জাস্ট একটু প্রেক্ষিতটা বোঝাতে চাচ্ছি। বাংলাদেশের প্রেক্ষিত আমরা সবাই জানি, কিন্তু ওনাদের কাছে আমরা কেন ওনাদের কাছ থেকে আমরা আসলে আজকে কি আশা করছি। একটা বিষয় হলো যে কোনো ক্রান্তিকালীন সময়ে যে কোনো যুদ্ধ বা সংঘাতমূলক একটা প্রক্রিয়া বা আন্দোলনের পরবর্তী একটা প্রক্রিয়া যখন রাজনৈতিক পট পরিবর্তন হয়, এবং সেই আন্দোলনের মধ্যে এবং আন্দোলনের আগে এবং আন্দোলনের প্রেক্ষিত যখন গুরুতর মানবাধিকার লঙ্ঘন হয়, পরবর্তী সময়ে হয়তো মানবাধিকার লঙ্ঘন হতে থাকে, সেই প্রক্রিয়াগুলোর মধ্য দিয়ে একটা সমাজ বা একটা জাতি বা একটা রাষ্ট্র কিভাবে এগিয়ে যাবে, সেই বিষয়গুলো বোঝা দরকার। আমরা ওই পরিস্থিতির মধ্যে আছি। আমরা এক এক দিন এক একটা জিনিস আবিষ্কার করছি, বিভিন্ন প্রতিবন্ধকতার সম্মুখীন হচ্ছি, নানান ধরনের সমাধান আমরা তৈরি করার চেষ্টার মধ্যে আছি। আমাদের এখানে যারা আছেন আপনারা প্রায় সকলেই আইনজীবী, অনেকে বিভিন্ন গুরু দায়িত্বেও আছেন। এই মুহূর্তে শিরনাপা আছেন, উনি একটা সংস্কার কমিশনের দায়িত্বে আছেন। আমাদের পান্না ভাই আমাদের সিনিয়র আইনজীবী আছেন, আরও সিনিয়র আইনজীবীরা আমাদের সাথে আছেন। এবং যারা আমাদের এর আগে, যাদের আমাদের মুক্তিযুদ্ধ পরবর্তী অবস্থায় কী ধরনের মানবাধিকার লঙ্ঘন হয়েছে, যুদ্ধ অপরাধ হয়েছে, সেগুলোর বিচার যারা চেয়েছেন বিভিন্ন সময় ধরে, তারাও আমাদের সাথে আছেন। তো আমরা আশা করছি আমাদের ঠিক যে অডিয়েন্স দরকার ছিল আলোচনার জন্য, তাদের অনেকেই আমাদের সাথে আছে। সো প্রথম প্রশ্ন ছিল যে এই পরিস্থিতি কিভাবে মোকাবেলা করা যায়, কি করে এগিয়ে যাওয়া যায়। দ্বিতীয় বিষয় হচ্ছে যে আন্তর্জাতিক আইনে অনেক কিছু এর মধ্যে তৈরি হয়েছে গত 30-50 বছর ধরে, কিন্তু আজকে আমরা অনুরোধ করেছি দুই বক্তাকে যে যতটা বেশি আমরা ওদের কাছ থেকে আন্তর্জাতিক আইনের বিষয়ে শুনতে চাই, আমরা আরও বেশি শুনতে চাই ওদের অভিজ্ঞতা সম্পর্কে। কারণ আইন তো এক, সবার জন্য প্রযোজ্য, কিন্তু আইনের ব্যাখ্যা দিতে হয়, এবং এই ব্যাখ্যা দিতে হয় এক একটা পরিস্থিতি, এক একটা প্রেক্ষাপটের মধ্যে, যার প্রেক্ষাপট ভিন্ন। আমরা কোনোভাবে সাউথ আফ্রিকার এক্সপিরিয়েন্স ট্রান্সলেট করে বাংলাদেশে নিয়ে আসতে পারবো না, সিয়েরা লিওন বা কলম্বিয়া নিয়ে আসতে পারবো না। আমাদের প্রেক্ষিত আমাদেরই, এবং আমাদেরই বুঝতে হবে আমরা কিভাবে এগোবো। কিন্তু হয়তো কিছু কিছু শিক্ষা আমরা ওদের কাছ থেকে নিতে পারবো, কি করা যায়, কি করা উচিত, কি সফল হয়, কি ফেল করে। মেবি ওই শিক্ষাগুলো নিয়ে হয়তো আমরা একই ভুলগুলো করব যেগুলো ওরা করেছে, এটা আমাদের স্বাধীনতা। কিন্তু আমরা কি করে ভুল এড়াতে পারি, হয়তো সেই শিক্ষা আমরা ওদের কাছ থেকে নিতে পারবো। তো যেটা আমরা ওদের সাথে আলোচনা করেছিলাম এখানে আসার আগে, আমরা একটু শুনতে চাই যে এই ক্রান্তিকালীন ন্যায় বিচার বা ট্রানজিশনাল জাস্টিস, এটা কোন প্রেক্ষিতে কিভাবে বাস্তবায়ন হয়েছে, কি ধরনের চ্যালেঞ্জেস তারা ফেস করেছেন, এবং কি কি বিষয় তারা দেখেছেন। একদিকে হচ্ছে অবশ্যই জবাবদিহিতার ব্যাপার, আরেকটা বিষয় হচ্ছে যে যারা ভিকটিম, যারা ক্ষতিগ্রস্ত, বাংলাদেশে যেমন হয়েছেন, যারা তাদের স্বজন হারিয়েছেন গুরুতর মানবাধিকার লঙ্ঘনের কারণে, তারা কিভাবে সুবিচার পাবেন, এবং তাদের শুধু সুবিচারটা না, তাদের পাশে দাঁড়ানো, কি করে তারা তাদের লাইফ আবার কোনো ধরনের ট্র্যাকের মধ্যে নিয়ে আসবেন, সেটা করার জন্য কি কি করণীয়। আমরা বাংলায় ক্ষতিপূরণ শব্দটা ব্যবহার করি, কিন্তু ক্ষতিপূরণ আসলে পুরোপুরিভাবে ক্ষতিপূরণ বলতে আমরা অনেক সময় in a way it's the right word, in a way it's the wrong word, কারণ এই শব্দ দিয়ে আমরা বুঝি আর্থিক ক্ষতিপূরণ, কিন্তু ক্ষতিপূরণ আরও অনেক কিছু হতে পারে, যেটা ইংরেজি শব্দ রেপারেশনও সেটা বোঝানোর চেষ্টা করছে, সেটার মাধ্যমে সেটা আমরা বোঝার চেষ্টা করি। আর লাস্ট পয়েন্টে আমরা ওনাদেরকে অনুরোধ করেছি বলার জন্য যে in addition to these justice processes, justice বলেন, reparation বলেন, accountability বলেন, সত্য উদ্ঘাটন করার জন্য কি করা যেতে পারে? সবকিছু কোর্টের মাধ্যমে সমাধান করা সম্ভব না, এবং আমরা জানি আমাদের প্রেক্ষিতে আমাদের কোর্টগুলো কত ওভারবার্ডেন, কত চ্যালেঞ্জ কোর্টের মাধ্যমে কোনো কিছু আসলে বের করে নিয়ে আসা। তারপরেও চেষ্টা আগেও হয়েছে, এখনো হচ্ছে। বাট কোর্টের বাইরে আমরা নাগরিক সমাজের মধ্যে কি কি ধরনের উদ্যোগ নিতে পারি টু create frameworks for transitional justice which allow us to move forward. এই জিনিসগুলো আমরা আপনাদের কাছ থেকে বুঝতে চাই। They will talk about all of these issues and more. Just in one sentence for both of you, we are hoping to hear from you, as we've discussed, about the context and experiences that you both faced, definitely about prosecutions, definitely about accountability processes, and I must mention, I think also for Carlos, who I barely mentioned, I talked a lot about you, Yasmin, that Dr. Carlos was also involved in the Pinochet trial, or the attempt to bring Pinochet to account, General Pinochet. Many of you will remember, who are older like me, and younger people may not. General Pinochet was the dictator of Chile, responsible for appalling gross human rights violations in the early 70s. And there were efforts more than 20 years later, in the 90s, to try to bring him to justice. So Carlos will tell us about prosecution processes, and particularly importantly, about universal jurisdiction, about the fact that it's possible to bring people to account even beyond our own national territories in other contexts. So I'm going to turn over to the speakers. The way we've arranged the program, we are of course running late. We hope to hear for about 30 minutes from each of the speakers. First Yasmin, and then Carlos, and then we'll have time excuse me, for discussion. So আপনারা প্রশ্নগুলো রাখতে পারবেন। আমি শুধু আগে থেকে বলে রাখি, কেউ যদি পারেন একটু হেল্প করতে আমাদেরকে, প্রশ্নগুলো যদি আগে একটু লিখে রাখেন আপনার নাম সহ, আমাদের ভলেন্টিয়াররা 2 আইলে আছেন, আপনাদের থেকে নিয়ে নেবেন। আমরা যাতে সময়টা ঠিকমতো ব্যবহার করতে পারবো, লিখিত প্রশ্ন পেলে সুবিধা হবে। আপনার কাছে অবশ্যই আমরা যাব প্রশ্নটা রাখার জন্য। অনেক ধন্যবাদ। Yasmin, over to you.
slideshow একটু slideshow কি এখানে PowerPoint প্রেজেন্টেশনটা
Good afternoon. I'd really like to thank Sarah and the Bangladesh Legal Aid and Services Trust for inviting me to participate in this discussion at such an important time. I also started my career as a young lawyer working for a legal aid organization in South Africa. And in fact, some of my first experiences were really dealing with people who had been detained, who had been tortured by the apartheid state, and really trying to use elements of the law to in fact assist people, even though we knew that because the judiciary was an apartheid one, and because the prosecution was an apartheid system, that it was certainly going to be difficult. But what I do think the lesson that we learned then was that the law could be used as a tool even in the most difficult times. What we didn't expect, of course, in our lifetimes was that we would experience freedom in South Africa. And that was really because of what was happening globally in the world. The Cold War had come to an end. The Soviet Union, as it was then, and the Chinese government no longer had an interest in supporting the liberation movements. And in the case of the Americans who had been supporting the apartheid system, they no longer had an interest in bankrolling the apartheid government. And in a very strange coincidence, all three of these major global players began to tell the liberation movements and the apartheid government that you now had to begin to negotiate with each other. And so in our instance, unlike in many other parts of the world and even in Bangladesh, we didn't have any winner of the war. There was no victor. And in fact, we had to come to the negotiating table because of a negotiated settlement in which each side had to agree on what the basis was for, in fact, beginning the transition in South Africa. Neither side trusted the other. And so one of the first things they did was, in fact, to set up a transitional executive council, which had representatives from all sides, and which began to think about what the important questions would be for the transition to take place in South Africa. One of the first issues, of course, was the question of how do we manage the security forces? How do we ensure that they're not going to go rogue, which they did do during the transition? How do we make sure that the military and the police can be trusted to, in fact, safeguard the transition? And as we found out later, we still didn't have the answers to that. One of the big questions, of course, was what are we going to do with those who were responsible for the whole question of crimes against humanity? And remember that in South Africa, apartheid had been declared a crime against humanity by the United Nations. And so the big question that was really plaguing the negotiators was this question of what do we do with those who were responsible at a command level, who planned and authorized these crimes, and what do we in fact do with those who were the foot soldiers? And it was very interesting because this was a question which held up the signing of the interim constitution. It was the last question that was dealt with, and people talk about the agreement only being reached at midnight because on the one side, the apartheid president, F.W. de Klerk, had promised the generals that he would get them a blanket amnesty. On the other side, there were people in the liberation movements who said, no, why don't we do to them what they did to us? Lock them up and throw the keys away. And then there was a third group who actually said, well, we were fighting a war, and in that kind of war, you have civilian casualties. And that side was not too concerned about the morality of the fact that there had been hundreds of thousands of victims, many of whom had been killed, many of whom had been disappeared, and in fact, the notion of torture was endemic to the way in which the apartheid system, in fact, operated. And so the dilemma that we faced, and in fact many countries that undergo transition face, is this question of how do you deal with impunity? How do you deal with those who are responsible for impunity? How do you begin to build accountability in any state? And how do you bring justice to the victims? And of course, a very big question that was doing the rounds at the time and we in South Africa were confronting this as well, is many argued that there should be peace first and then only you could have justice. And there were others who argued, like the former apartheid government, that peace and ending hostilities was a almost a kind of precondition of justice. And then, of course, there was the expectation from victims that they would have access to reparations, but also that there would be accountability and their perpetrators would have to account, and that they would be entitled to reparations. Now, it's very interesting, and just like I am standing here today, I can tell you that there was an enormous amount of traffic between South Africa, Latin America, and Eastern Europe, as experts would come from those situations themselves came to share what had happened in their own countries. Now, I put a quote here from Boli Soyinka, who is the Nigerian writer who was executed by one of the regimes. And he said that impunity exists in a country when those in power systematically abuse human rights, they commit crimes, and they exclude others from any kind of opportunity without fear of the consequences. And in fact, that is how it takes the form either of racism, discrimination, inequality, and of course they use harsh methods like torture and disappearances to in fact enforce that kind of regime. And he spoke about the fact that it results from profoundly unequal power relations, and which, if unaddressed, they also begin in fact to have a historical implication, as we see in many of our countries. And usually it's because authoritarian governments hold on to power. And one of the most important facets which we saw in our own country and many countries across the world is that you have the capture of really important political institutions by political elites. In my country, the capture was of the judiciary. We could not expect that the judiciary would act fairly, without fear or favor. It was the way in which the prosecution and the investigative services had been captured, as well as other public institutions. And so one could not rely on any kind of justice. And this is something that we have to consider in South Africa. How will we deal with those institutions which have been tainted by their participation in human rights violations, which amount to grave crimes and mass atrocity crimes? And that's a question that is faced in many, many countries across the world. Do you chuck them all out? And that was something we had to consider. And we realized that if we did, the whole state would collapse. And so we had what we called a sunset clause and an amnesty period. And that was to, in fact, give those who came forward voluntarily an opportunity to speak about what they had been involved in, to do so in a public way. And if they made, if they told the truth and they made a full disclosure, and if they could prove that they had acted in pursuit of the aims and objectives of the former state, then of course they would get amnesty and they wouldn't go to jail. Now, there's been an evolution really of that kind of model, and my colleague Carlos Castrasena will speak to the way in which Colombia adopted part of that. But what they didn't allow was the impunity of not being convicted, and of course not having to deal with the question of sentencing. And that has taken a period of almost 20 years to get to that kind of evolution. So when we look at what we would call the genealogy of transitional justice, and remember, all I would say is that when we talk about transitional justice, what we're really talking about is how do you deal with the past? And how do you hold perpetrators accountable? Because that's the burning question which each one in our society is always thinking about. In my society, when we discovered that in fact they had agreed that there would be no prosecutions and there would be an amnesty process, I remember calling the First Minister of Justice, who was a mentor of mine, and I said to him that night, you have sold us out, and you have also sold the victims out. And he was quite sort of, what's the word, cynical. He was very rude. He said, well, you lot in the human rights community, you can stand outside and you can scream and shout and do whatever you like, or you can decide that you will participate in the discussions around the framing of the law so that we can build a broader process in which there will be some form of accountability. And this was a really difficult question for us because we had to decide, do we want to participate in what we thought of as impunity, or do we create greater accountability through this process? And so 50 human rights organizations, together with the religious community, we came together and we nominated a few people to go into that discussion process. Now, it's a very difficult question. How do you tell victims that you have dealt with for a period of 10 or 20 years, sorry, my friend, there's not going to be justice? If these people come forward and they tell you, yes, we killed your husband or your daughter, and if they tell the truth about it, then they're going to go scot-free. And that is an incredibly difficult issue to deal with for any victim. But what we were seeing, in fact, is what our Latin American colleagues were telling us. And there was a very famous debate that was happening at the time. The advisor of President Aylwin, who was the president in Argentina, who took over when the military dictatorship stepped down and gave themselves an amnesty, when he tried to prosecute the perpetrators, he almost lost power. And so the debate at that point was, do we go ahead and prosecute? And if we do, it is quite possible that there could be a coup against us, those of us who take power validly. And so this was the burning question of the 1990s. When we look at this field of transitional justice, how do you deal pragmatically with the fact that you want to hold people accountable, but at the same time you have to be careful if they still hold the power? How do you ensure that they don't unseat you? And that was a real question that we grappled with in South Africa as well. And so I think what we draw from this is that there have been sort of three phases. The first phase was the phase of Nuremberg, where the Allies in fact staged criminal trials. But if you look at the critique of that period, many people say it was selective and it was victor's justice. And that in fact amongst the Allied forces, the crimes that they had perpetrated never actually went punished. If you look at the second phase, this is the phase of what we call pragmatism. We say that in the interests of really building the rule of law, that is when we have this new accountability process, which we call the Truth Commission, which began to deal with accountability from the broader perspective of the right to the truth. And of course, in the third phase, we see the return of international criminal justice in the form of the ad hoc tribunals, the Special Court for Sierra Leone, the Court for Cambodia, and of course the setting up of the International Criminal Court. So in that, genealogy, as I talked about this famous debate, and at that time there was a debate about, so what is a state's obligations? Under international law, we say that the state has a duty to prosecute. It has a duty to investigate, and where the evidence exists, it has a duty to prosecute. And Carl Nino, who was President Aoun's advisor, said, well, that's all very well, but what should be the case if the political context is such that if we were to prosecute, then we will lose power? And in the end, both of them agree that you have to look at what the political context is and what is pragmatic in order to allow you to survive, to have accountability at a later point. Of course, what happens in this period, of course, is that because Argentina and Chile couldn't prosecute their military dictatorships, many years later, you have a Spanish magistrate in the form of Carlos and his colleagues, who then decide to use this concept of universal jurisdiction and to try and hold General Pinochet accountable. But how do they do it? They do it through the courts in the UK. And he's going to tell you that story, because I think what it raises is how you can use other international jurisdictions in the absence of being able to deal with perpetrators at a domestic level. Now, what developed out of these debates, of course, was what we began to call the principles to combat impunity. The United Nations, incredibly concerned by what was happening in Latin America, and the fact that the military dictators were stepping down, yes, but before they did, they gave themselves amnesty and they gave themselves immunity, and they said nobody can prosecute them for the crimes they committed. And so Louis Joinet, a French magistrate, was sent to Latin America, in fact, to investigate what was going on. And as a result of that process, he developed what was called the principles to combat impunity. And Joinet spoke about 4 principles. Firstly, he talked about the fact that a state has obligations. The second is, he said, is that victims have an inalienable right to the truth, and that that right is imprescriptible. In other words, nobody can ever take that away from you, and that right can never prescribe. And what is very important is that these are not new obligations, but rather they became a codification of what was out there under international law already. And so the Joinet principles, as they became known, consist of 4 principles, 4 pillars: the right to the truth, the right to justice, the right to reparations, and the guarantee of non-recurrence. In other words, if you get all of those 3 right, and you build new institutions, you deal with security sector reform, and you clean out all the bad apples, because the bad apples create a systemic culture in which it doesn't matter if you change the faces, but the impunity in a state will continue. And that is what he called the guarantee of non-recurrence, or what we call the never, never again principle. But one of the latest rapporteurs on the right to the promotion of truth and justice, a man called Fabiani Salvioli, he in the last year wrote a paper called The 5th Pillar. And that 5th pillar deals with the question of memory and memorialization. And I think the more you begin to deal with this, begin with the past, you begin to realize how important memory is, particularly for victims, for a society and, in fact, for their families. Now, when we talked about the right to the truth, in a way, the mechanism that has been used across the world to deal with implementing the right to the truth has been what we call a truth commission. Now, Latin America had some of the first truth commissions, one in Chile, one in Argentina, and one that the UN set up in El Salvador. But the one that became a pivotal turning point in the world was the South African Truth Commission, because that became the first commission in the world to begin to hold public hearings, and not only to look at the question of the individual right to truth, but it also began to look at this question of the historical context and, in fact, the structural underpinnings of the state, which, in fact, give rise to these kinds of violations. And that has been an important basis for many countries to build on. There have been more than 53 truth commissions around the world, with the latest ones being in the Gambia, one in Colombia that is sitting together with what they call their special jurisdiction for peace. And there's a recognition that victims can come forward and speak about what has happened to them, and that it's really important for a public body to officially hear them, to acknowledge what they say, and to recognize them, and to restore to them the rights as citizens. But that is not enough in any society. We need to know, how did it happen? Who gave the orders? Who planned that? The question of what we call the linkage to the question of command responsibility. Because, you know, you can deal with individual perpetrators, and usually in many countries, we deal with what we call foot soldiers. But until we deal with those who are right at the top, we are never going to change our society. And so that's an important component. Thank you for that. So, you know, some of the dilemmas which I think we confront in the work that we do is denial. In my country, in fact, the apartheid government denied that they had been responsible for atrocity crimes. And so it was really important to deal with that denial. The other is an acknowledgement of what has happened to victims, and that across the world, it's important to, in fact, document what has happened to victims, the violations they've suffered, and how their families have had to deal with finding out what happened to a loved one when they were disappeared, what happened to their dead bodies, were they able to reclaim that? All of those things go to the question of, you know, the acknowledgement. But the other is, and that is the hardest lesson we have all learned, that the truth in and of itself is not enough. First, victims will say, we want the truth. When you give them the truth, they'll say, what are you going to do about the person who did this to me? And so that question of criminal accountability is a burning question which many societies grapple with. In my country, for instance, 30 years after the transition, we have 300 cases that we are trying to put through the courts so that the families can actually begin to deal with the perpetrators. The other thing is that for those who say, well, we should think about reconciliation, one of the biggest lessons has been that you cannot have reconciliation or national unity without justice. And justice and accountability are key components to that process. So let me, I think, talk about, you know, we've talked about criminal accountability, and we should remember that in many countries, it's really difficult. Give you an example. The International Truth and Justice Project, which I sit on, and my colleague Francis Harrison, who runs that project, is here today. We are sitting probably with the biggest archive of evidence on what happened in Sri Lanka during the civil war, in which so many people were killed, so many tortured, so many were disappeared, and for which there has been absolutely no justice. And so we then began to think about how can we use this evidence that we've gathered, and we decided that we would use courts in other countries. And so we called upon our colleague here, Carlos, and we said, help us. We're going to file a case under universal jurisdiction in 5 Latin American countries. Why the 5 Latin American countries? Because that is where the former head of the army had been posted to as the ambassador. And so we filed a universal jurisdiction case in Latin America. But you know what the Brazilian government did? They tipped him off, and he fled. And he went to Dubai for a while, and then he went back to Sri Lanka. But he will never travel. Do you know why he won't travel? Because he is so frightened that he can be picked up in another country. Then we also, before the former defense minister became the new president of Sri Lanka, he went to America, and we filed a case under the Victims Torture Protection Act. And we served papers on him in Trader Joe. That's a shopping complex in America. And we served papers on him, dealing with the period when he had tortured more than 11 victims under the time he was the defense secretary. The unfortunate thing, of course, was that he then won the elections in Sri Lanka, and he became president, and he was then entitled to immunity of office. And so we actually had to then drop that case, because if we had continued, we would end up paying these exorbitant legal costs. Now, Gotabaya, of course, had to step down from power when there were protests against him in Sri Lanka, because he had really, between him and his family, they had messed up the economy, and they'd also been responsible for atrocity crimes. And so he fled. He fled to Singapore, and then we filed another complaint against him under universal jurisdiction. And the Singaporean government told him, get out of here in the next 9 days, because if you don't, we might be forced to act upon that application. And so the big question you have to always think about is, how do you create a situation in which you make it absolutely unsafe for them to travel? Yeah, you want to grab them and you want to put them on trial. But if you can't do that, then the next best thing is put them on the run. The other thing that we've used quite successfully is what we call, these Magnitsky sanctions. And in the States, in the UK, in Canada, you have them. And we've got the general who is the head of the army. Both him and his family members were put under a visa and travel ban. Their assets, if they have them in the United States, they were frozen. And they're very bitter, because the one man's daughter, I think she's a lecturer, and she couldn't lecture in the States because of that. And so, he was punished really for the fact that he headed a very famous division that was responsible for most of the violence. We also have made sure through our work that the 2 presidents, the 2 Mahinda Rajapaksa and Gotabaya, they were sanctioned in Canada, so they can't travel to Canada, and neither can their families. We've had a number, in fact, of Navy personnel who were involved in the violence at the time sanctioned as well. And then we've kept the Sri Lankans out of peacekeeping, which was really important for them, because peacekeeping makes money not just for the country, but for the individual peacekeeper as well. And lay vetting applied to them because they were implicated in human rights violations. And so what I want to say is that there are a whole compendium of tools that we can use for justice and accountability. You have prosecutions, you have truth recovery, but you also have vetting and screening, you have universal jurisdiction, and these can make an enormous difference. Because one of the big issues is, how do you trust the judiciary? In my country, we had to set up a whole system to reform the judiciary, and we set up what we call a Judicial Services Commission to make sure that we clean them up. But, you know, that's a process that is happening across the region, where they clean up the judiciary and the prosecution so you can trust them. Because the worst thing that can happen is you can have trials. And if the evidence before those trials does not succeed because the judiciary or the prosecution are corrupt, then people become even more angry. I shall leave it there because I think I've used up more than my time, and we can deal with questions. Thank you.
Thanks so much, Yasmin. So maybe with no further ado, we go to Carlos now. Thank you. There you go, slideshow is good. Nice.
Technology.
Yeah, you can't do it without, is that right?
No, because it is very visual.
It's very visual.
It's almost pictures. screen now. Okay. It's very small. Okay. It works. Well, mysteries of the technology. Okay. Well, good afternoon. Thank you to the organizers for inviting me to this event with my friend many years ago, Yasmin Sooka, to explain some of the issues of transitional justice, and specifically in my case with the pillar of justice, of criminal justice, with a reflection that I will try to bring to you with 4 examples of Latin America. I participated personally in the 4th of them. It would take hours to explain the cases in some detail, but at least some guidelines of how it worked can give us an idea, which is the focus today, of what is criminal justice for in transitional processes. So what is the achievements that we try to get in transitional justice situations from the pillar of justice, other than the truth, the reparations, the non-recurrence, and the memorialization that Yasmin had just explained. This is my reflection of my experience of many years working in criminal prosecutions, using the tools of universal jurisdiction, in other cases using the instruments of the international community, in others just advising those dealing with the pillar of justice. The first evidence is that in transitional justice the situation is not perfect, it's very difficult, usually is unstable, so you will never get justice for all the victims, and you will never be able to bring all the perpetrators before a court of justice. But with limitation, the question is how to do it, why we do it, what is the goal we try to get. And I always illustrate this with the bridge. We live in a situation of conflict, of controversy, of violence, of corruption, and we need to cross. We want to go to a place where coexistence is peaceful and controversies are solved with the instruments of rule of law. But for crossing the bridge successfully and to go from conflict to coexistence, you need to deal before you cross with the causes and the consequences of the conflict, with the victims and the perpetrators, because if not, the conflict will cross the bridge with you and you will stay in the new situation, but the conflict will be repeated in one way or another. And in my view, after these years and these different experiences that I am very briefly trying to show you, the question about criminal justice in transitions is a demonstration effect. You cannot bring justice for everything, but you can make a turning point. The rule of law was destroyed in the previous situation. You need to do something that is important enough as to show clearly that you will be unable to fix the past, but you will be able to restore the rule of law in order to the controversies in future not being permitted to go into violence and corruption. So basically trying to bring some deterrence for perpetrators, because you will not punish all of them, but everyone will understand the message if you bring some justice in paradigmatical cases. The duty to prosecute is in the universal constitution we have given ourselves in the international community in 1966. It is the International Covenant of Civil and Political Rights, and Article 2 establishes the 2 duties from the states for the citizens regarding human rights. The states, before the international community and on behalf of the citizens, have the duty to protect and the duty to ensure. The duty to protect means respecting human rights from the authorities, the public officers. The duty to ensure means preventing the abuses in order not to happen, but if they happen, to react, providing a remedy, investigating, prosecuting, and punishing the perpetrator, and providing a reparation for the victim. This is what is very difficult in transitional situations, because the judicial system, so the security, the prosecutorial authorities, the judiciary, and the penitentiary system used to be part of the problem, not part of the solution. And in this situation, you need to find different ways. The conclusion of the cases of Argentina, Chile, Guatemala, and Colombia is that these kind of things you do usually, as the Beatles said, with a little help of my friends. And this means that in some cases, you cannot prosecute in the very same place where the crimes have been committed. You will need the universal jurisdiction tool to prosecute in other places, because it is clearly established many years ago in the international criminal law, the possibility to prosecute international criminals universally, internationally, because usually in the place where the crimes were committed is very difficult, because there are many resistances, because they have self-amnestied, because they still control the institutions, so they have a capacity to get impunity for them and their partners. So the first example, very briefly, is Argentina. It is probably the first country that came into a transition even before the end of the Cold War, and the democratic authorities first annulled the previous amnesty granted for the military, but then did seriously an attempt to bring justice for the victims, with the result that we will see. So there were a huge situation of abuses of human rights, crimes against humanity, because it was a persecution and inhuman acts in a widespread and systematic manner against civilian population on following a plan or policy. The definition is very clear. The dictatorship in Argentina killed a lot of people, disappeared a lot of people, but when the new democracy came, there is a statement extremely important from the president, Raúl Alfonsín: oblivion is not an acceptable option. You cannot build a democracy on impunity. This is the example of Germany. Who could think that Germany could become back a democracy if Hermann Goering was free? Obviously, it was impossible. So President Alfonsín brought the members of the military juntas to trial. They were convicted, but at the same time, after the judgment, there were 2 attempted coup d'etat, then 2 amnesty law, and finally 1 presidential pardon. And the most important responsible, General Videla, was set free after having been convicted to life imprisonment. But the victims did not give up and continue claiming for justice. This is extremely important. The claim of justice of victims makes possible justice to be brought. So the president was brought again to trial in Spain with the support of the Argentinian victims, using the tool of universal jurisdiction. He had been tried in 1984, but me, as part of the Union of Progressive Prosecutors, which is a professional association in Spain, brought a case against him in the Spanish courts. He was indicted. We asked for the extradition. Obviously, the extradition was not granted, but the situation began to change in Argentina itself. And finally, the parliament in Argentina was able to abrogate the new law of amnesty to put him in trial again, and he was finally convicted to life imprisonment and died in jail. But then the example of Argentina, when after trying to bring to justice the perpetrators, 2 attempted coup, was a very clear message for Chile, and the president of Chile was much more conservative, justice to the level of possible. They made the Truth Commission, they made a program of reparation for victims, but no perpetrator was brought to justice. And then General Pinochet became the paradigm of successful dictator committing thousands of crimes and being successful in gaining impunity, which is immunity for life. He was the commander-in-chief of the democratic government in Chile in 1973. He was the one who decided to make a coup d'etat, killing the president, destroying the presidential palace, destroying the democracy that Chile had never had a coup d'etat first, but he imposed a dictatorship of 17 years. This is the day of the coup. There were 3,000 people murdered in the next days, and 1,200 forced disappearances, and then almost 30,000 cases of torture, because Chileans are very ordered. They documented every case of forced disappearance and every case of torture, and many more went to jail or had to go into exile. And nothing happened because General Pinochet proclaimed himself head of state the next year in 1974, and in 1978, when he understood that he had killed all the people he had to kill to control the country, he decided to grant himself and all his cronies an amnesty. He never asked the population, and the first time he did was in 1989, 17 years after the coup, and he asked, do you want me to continue ruling the country? And the response was no, you have to go. But he prepared the impunity, keeping the immunity as head of state and transforming it into the immunity as commander-in-chief of the army, and then transforming into parliamentarian immunity, senator for life, for the rest of his life, so impossible to prosecute him in Chile, never ever. So we had to do something, because it is the main problem of impunity. It's not only a violation of Article 2 of the International Covenant of Civil and Political Rights, but it's the denial of justice for victims. There are not reparations, there are not rights to justice. It applies to state and non-state actors equally, but usually to state actors, and represents that law exists but cannot be applied. The question is looking for a way to apply the law, because if not, there is not rule of law. There is not a real democracy, because democracy, we usually think, well, it is elections. Well, it is election, but it's also legality. If authorities are not submitted to legality equally as any other citizen, you cannot speak of a real democracy. But igual, the same case as in Argentina happened in Chile. The victims did not give up and continued claiming for justice. And then the Spanish progressive prosecutor decided to bring a case before the Spanish courts. And we included the count of genocide, because the process, as they so-called, of restoration of Chilenity represented the killing of so many people, as I have already explained. We put the count of terrorism, because there were several actions, the most important actions that were critically, very clearly crimes of terrorism, but terrorism has not very much acceptance in international criminal law, because it is very political, because it is contentious, but we still try. And finally, torture, because torture is the only international crime in which we have got some kind of unanimity in the international community. So a bomb exploded the former commander of the Democratic Army in Chile, which is clearly a terrorist attack. Another car bomb exploded with the former Secretary of State, Orlando Letelier, in Washington. And Bernardo Leighton, the director of the Christian Democracy, was already attempted to be killed in Rome. Torture is the one that finally succeeded, because genocide has many difficult implications in the intentional component, and terrorism, as I said, is very contentious. But torture, everyone accepts that it is an international crime. Everyone interpret equally according to the 1984 convention, and it worked very well. So finally, after 2 years, not really investigating ourselves, but being able, which is another lesson for lawyers of human rights, the legal aid organization that has organized this event today, we were able to bring the work done by Chilean human rights lawyers during 25 years. They were gathering the evidence, the information of the 1,200 forced disappearances and the almost 30,000 cases of torture. So we were able to bring to the Spanish court and then to the British courts all this evidence, and the case was done, really. But the High Court decided that General Pinochet enjoyed immunity because he had been head of state, so he could not be prosecuted only in Chile or in an international court. We obviously didn't agree with this decision and decided to bring the case before the House of Lords. He was arrested, then the High Court granted immunity, but we insisted, and the Spanish tribunal decided that we had jurisdiction, that the universal jurisdiction applied, and that he had not immunity because he was not anymore head of state, and the acts that he committed being head of state cannot be protected by immunity, cannot be considered acts of authority. Torture cannot be protected by international law, so immunity cannot apply. So basically, in November we won. The House of Lords decided by 3-2 that he didn't have immunity, but the judgment was declared void immediately, and then General Pinochet stayed 500 days in house arrest in London, where we were discussing again in the House of Lords, and then the extradition process. In March 1999, the difference between the first debate in the House of Lords and the second debate was that the government of Chile began to activate his position, telling that he had to be sent back to Chile, but the House of Lords this time made something much easier. They said, well, let's discuss first what are the crimes that justify the extradition, and then let's analyze the immunity regarding these crimes. They excluded genocide, they excluded terrorism, they focus only in torture, and say this is the crime. But in order not to violate the sovereignty of Spain, the United Kingdom, and Chile, they decided that only torture committed after the date that the 3 countries had ratified the 1984 UN Convention Against Torture could be extraditable. So only torture committed after December 1988. No immunity as head of state because he was not anymore head of state. No immunity because of the acts committed, because torture cannot be an official act in any case. And then 6-1, they decided to create a precedent to indict a head of state on grounds of universal jurisdiction for the first time ever, and to leave way to the process of extradition. In October 1999, the extradition was granted, and was granted not only on the 35 cases of torture documented after 1988, but on the 1,200 cases of forced disappearances that, according to the jurisprudence of the Inter-American Court of Human Rights, were considered torture for the disappeared persons and for the family members of the disappeared person. In the case Velázquez against Honduras. But you know the story is that in 2000 the government of the United Kingdom decided not to grant the extradition but permit Pinochet to come back to Chile because of health reasons. He was permitted to come back, and he came very happy to the same country, but it was a mistake because he was the same old dictator, but the country was not the same, not at all. The Supreme Court, 2/3 of the members elected by himself, decided to deprive him of immunity, and the Chilean judge decided that he was fit for trial, so he was indicted on international crimes. time going on, he was indicted after that because the Senate made an investigation and discovered that he had a lot of money in the US and in, well, 5 minutes, okay, and in other places. He was finally indicted on counts of corruption, to tax fraud, money laundering, embezzlement, and finally he died. Never tried, but the turning point was made. Chile was already a different country. The fact that Pinochet could be prosecuted internationally made possible to culminate the process of transition. Well, this is the grounds, the crimes against humanity that were created in Nuremberg. The Nuremberg principles, I can leave the presentation later because if not I will have no time. The Nuremberg principles that are still today in the Rome Statute of the International Criminal Court, the extraterritorial jurisdiction established in the Geneva Conventions and applied in many different situations to Adolf Eichmann in Israel, but to General Pinochet in Spain. And another model is Guatemala, but I have no time, I will go very fast. In some cases, there is not a question of prosecuting abroad, it's a question of reforming the security and justice system to make it functional, because it is, as I said in the beginning, part of the problem instead of part of the solution. This is the case of Guatemala, where they were able very successfully to put an end to 36 years of armed conflict with a very good peace agreement. They made peace, but they didn't build the peace. They were unable to implement the measures established in the peace agreement. So 10 years later, this is the example when you cross the bridge, but you don't deal with the causes and the consequences. 10 years later, the conflict had transformed from political violence into common violence, into organized crime violence. And at the time, the justice system was virtually collapsed, and Guatemala was the deadliest place ever in the world, including Iraq and Afghanistan at the time. So where more people were violently murdered was the district of Guatemala City. And then Guatemala asked the support of the international community. The UN created the CICIG, the International Commission Against Impunity. I was appointed commissioner, and we had to begin in the beginning because we had not a counterpart. We had to select, to train policemen, prosecutors, and judges in order to be able themselves, with a little help of the international community, to do their own jobs. We made legal reform proposal, we trained the policemen, we trained the prosecutors, we were able to create a court in Guatemala City with jurisdiction in all the country, because the country was 60% on the control of Colombian and Mexican cartels, and nobody could bring justice there. And we began to build the willingness, which is very important, to talk to the people, to explain what you are doing, and trying to bring them that are extremely skeptical to believe in justice. But for them becoming believers, you need to show that justice can be brought. So we were a lot in the media. We tried to work, we worked with the victims and with the civil society. We began to remove the political obstacles, those who were not following the mandate, who were not cooperating, the different authorities in different important institutions in the security and justice system. And after we have removed the political obstacles and we have trained a reliable counterpart, we were able to begin to produce results. So we began to put in jail the most important perpetrators, most of them from the time of the armed conflict, but with the strategy of low-hanging fruit, we could not prosecute them on crimes of the armed conflict, so we prosecuted them in tax fraud, like the case of Al Capone. He never was punished for his crimes, but he went to jail because he didn't pay taxes. So something like that. Important authorities, some of them in Guatemala, some of them in other countries, which is very important also for the idea of building a network of cooperation if you are dealing with this kind of prosecutions. And the system changed. From 98% of impunity, we went into 100% of convictions. And then the former president was arrested when he was escaping the country to Belize. He managed to escape from the country finally to be free, but we had a plan B, which was indicted him also in the US, where he had laundered the money, and he was convicted into the US. And then the genocide victims decided to bring charges against the former dictator, and he was also tried and convicted. And the claims of justice, because justice is addictive, the more you get, the more you want. You never got satisfied. Brought to trial the next democratic president on counts of corruption, and he was put in jail. And this is the consequence. When we arrived, the violence was in the top of the situation. You see 2000 in the peace agreement. Then you see 2008, when the commission was created. The violence had doubled from 26 to almost 50 murders every 100,000 inhabitants a year, and we were able to bring back to the numbers. And the final example, I cannot develop this, but this is Colombia. They made an agreement. They had been more than 50 years fighting different insurgent groups with the governments. They made a peace agreement, and they created a special jurisdiction for peace, focusing on the victims. It is a system supposedly created on behalf of the victims, where the perpetrators, if they want to get advantages, they need to accept their responsibility, to make a full disclosure of their facts, their crimes, and the crimes that they have information of other people, and then they can get the benefits of the system. The system was integral, created with a truth commission, with a reparations authority, with a special office for looking for the disappeared, and with a special jurisdiction for peace. In this, if you cooperate, you get some kind of advantages, not prison sanctions. If you do not cooperate, you can get until 20 years of imprisonment. There are different chambers composing the court, and there are alternative penalties, like working in the reconstruction of the country that they destroy. You destroy, now you restore. And then finally, this is the message. I think that in these transitional processes, the goal is crossing the bridge from conflict to coexistence, but also playing by the rules, restoring the rule of law. Thank you.
Thank you so much, Carlos. আমরা এখন প্রশ্নোত্তর পর্বে যাব। আশা করি আপনারা সবাই সুযোগ পেয়েছেন আপনার প্রশ্নগুলো লিখে দিতে। কারো কি প্রয়োজন আছে কাগজ কলমের? এখন একটু বলবেন, ভলান্টিয়াররা দুই সাইডে আছেন। We have a few questions for both of you, and I guess everyone is running late. আমাদের এখনই শেষ করার কথা ছিল 1 মিনিট আগে, সো আমি আপনাদের থেকে একটু সময় নিয়ে নিব। আই থিঙ্ক আমরা আরো 15-20 মিনিট চালাতে পারি প্রশ্নোত্তর পর্বের জন্য। আমাদের প্রথম প্রশ্ন হচ্ছে, right, the question may be for each of you. So the first question is, geopolitics is a big issue in the current global context. To achieve effective sanctions on perpetrators, developed countries play a vital role. What happens though when these countries support the perpetrators, and how will justice take place? আমরা জানি এর আগেও গত সরকারের আমলে আমরা দেখেছি যে জাতিসংঘের থেকে না হলেও কোনো দেশ, বিশেষ করে যুক্তরাষ্ট্র, স্যাংশন দিয়েছিল কয়েকজনের বিরুদ্ধে, যেমন র্যাবের চিফ, পুলিশের চিফ ইত্যাদি। এবং স্যাংশন দেওয়ার কারণে স্যাংশনকে অবজ্ঞা করার চেষ্টা করা হয়েছে একদিকে, তো স্যাংশনের হয়তো কিছু ইম্প্যাক্ট হয়েছে। তো এই সময় স্যাংশন দেওয়া হচ্ছে কিনা, আর স্যাংশন দিলে যদি কোনো দেশ স্যাংশন না দিয়ে বরঞ্চ প্রশ্রয় দেয় যারা মানবাধিকার লঙ্ঘন করেছে তাদেরকে, তখন কি করা যাবে? Would you both like to take a stab at one of you?
I think that one of the things we can't deny is the way in which geopolitics plays a role in dealing with international justice. And we've just seen in, I think, the last few days, where the United States has, in fact, said that the RSF in Sudan is responsible for genocide. And yet, when you consider what has been happening in Gaza, it just seems quite hypocritical that the United States won't actually say that what the Israeli government is doing is exactly what the RSF is doing. And I think that this is an issue that we really come up against. And I mean, when we talk about effective sanctions, we're talking also about, I think, how do we use universal jurisdiction in a particular country to, in fact, make sure that they, if they travel or if they have property there, that they can be indicted. The second is, of course, this question of making sure that under these global Magnitsky sanctions that have been set up in many countries, that in fact they can be applied to perpetrators. And of course, in the case of the United States and many countries in Europe, they have additional forms of sanctions. And it seems that even though, you know, it's an interesting thing with sanctions, you don't have to prove beyond a reasonable doubt that somebody has committed a particular crime. All you have to establish is that there's a reasonable basis to believe that they were responsible for doing these crimes. And yet, it is so political. In fact, what we notice is that when you look at the United Kingdom, for instance, for many, many years, lawyers in the UK have been campaigning, as well as politicians, that in fact Sri Lankans who were involved in the civil war should in fact be sanctioned. And we've submitted many submissions in the case of General Shavendra Silva, in the case of General Jagat Surya, and yet the UK did nothing. And it's only fairly recently that they indicted 2 people, but in fact that was more along the lines of economic crimes than actually human rights violations. And yet when you begin to look at this question of atrocity crimes, you find that there definitely is a link between the atrocity crimes and in fact economic crimes and corruption. And there's such a reluctance on the part of the international community to really take our people, particularly if they still hold official office. And that's where the role of organizations comes in, because you see, you can have groups like ourselves who make these submissions, who put the facts together, but what you need is advocacy and lobbying to make sure that something actually does happen. But I think the biggest test of hypocrisy has been around the question of what has been happening in Gaza. It's actually turned the international legal system that we built up after the Second World War, it's turned it completely upside down. And all the rules that apply around international humanitarian law, international criminal law, all of those have become, I think, it's really difficult to argue with many young lawyers that you see fairness and equity. And that's why the case that is before the International Criminal, in the International Court of Justice is going to be so important on this ruling on the genocide issue, because how come you only have a few countries where the world, in a sense, recognizes genocide, but in many other countries where you have had genocides happen, there has been no or little recognition of that. And granted, genocide is a very difficult crime to qualify. But when you look at the way in which the discussions take place, I think what you begin to see is this question of hypocrisy. And you see that with, for instance, the prosecutor of the ICC having opened up these cases and preparing these arrest warrants. Immediately some European countries went to talk about how they are going to sanction ICC staff, and I think that that is a real problem, and that is something that we all need to discuss around. How do we begin to combat that? The extradition issue is another big issue in the world, and I think that Brazil made sure that General Jagassurya was able to get out. You look at General Pinochet, I think you had a similar problem, and we can go around countless places in the world, and you find that countries are not willing to give up somebody. And yet, the pressure that was placed on African countries at the time when the former president of Sudan was in fact indicted, and remember, Sudan was not a signatory to the International Criminal Court at the time, but when you look at the way in which
that's media's mic. Sorry. Well, I think that question just ran out. Unfortunately, Yasmin, sorry. We have a few more. We have a few more questions. I'm going to give them all to you because we only have about 10 minutes, so we need maybe shorter responses. I need to give the questions that have come before. So আমি আগেরগুলো দিয়ে দিই, তারপর আপনি লিখতে পারেন। ওনার কাছে একটু কাগজ দিয়ে দেন। আমার একটু প্রশ্নগুলো আগে দিতে হবে, যারা আগে দিয়েছে, I'm sorry. So একটা প্রশ্ন আছে from Advocate Khan Khaled Adnan. The question is, does customary international law generally apply to international criminal trial processes, even if the international crimes are tried domestically? And where would we get the sources of customary law from? I'm going to give you the other questions and maybe just repeat them. Another question is, how can international law be used to effectively prosecute individuals within complex command structures while navigating the issue of superior orders? Then another question, this is very important I think for us, if only knowing the truth as a victim is not adequate, what would you recommend to ensure that victims can get relief and also get criminal justice? So, শুধু সত্য উদ্ঘাটন যদি যথেষ্ট না হয় কোনো ভিকটিমের জন্য, তাহলে ওনার জন্য আসলে জবাবদিহিতা পাওয়ার কি প্রক্রিয়া আছে, এটা শেষ প্রশ্ন। আর আগের প্রশ্নগুলো ছিল যে এই কমান্ড স্ট্রাকচার নির্দেশনা দেওয়া, আদেশ দেওয়া বা নির্দেশনা দেওয়ার বিষয়টা কিভাবে, এগুলো আমলে নিয়ে কিভাবে প্রসিকিউশন করা যায়। আর তার প্রশ্নটা ছিল যে কাস্টমার ইন্টারন্যাশনাল কিভাবে অ্যাপ্লাই করা যায় জাতীয় পর্যায়ে যখন প্রসিকিউশন করা হয়। So any of those questions?
I wanted to say something just about the global sanctions. The international criminal law is something that we can never forget is political in nature. There is not a case of international prosecution that has not political implications. So the question is taking into account that there will be always double standards. I have made a proposal that maybe will take time. It's beginning to happen with the General Assembly of the United Nations. We need to go to the corporation. The General Assembly is doing much more for Gaza and the situation of Palestine in the last months that for many years have been made in the Security Council. So when there is this small group of countries with veto power, the decisions are not made, even if the grounds are very clear. But the General Assembly has not a veto power. And with the International Criminal Court happened the same thing. This kind of the decisions that are really applying double standards, the prosecution of the case of Uganda, not prosecution of the case of Colombia, for example, to say one historic, could be amended by the Assembly of State Parties. The Assembly of State Parties of the ICC is dealing only with the budget and this kind of questions of appointments of judges and the prosecutor, but they can deal with substantive issues if the court is not doing the right thing, in my view. Then, customary law is extraordinarily important in international criminal law because the international community works differently of the states. Domestically, politicians make a decision, and then come the law, and then come the application of the law, the practice, and the jurisprudence. In the international community works all the contrary. Begin a practice, the practice is sooner or later considered mandatory, and finally, the international bodies approve a convention. So the problem is persuading domestic courts of applying customary law, which is against their practice, and they are extremely reluctant, especially in the countries of the continental European system. The common law is more flexible, is more friendly with customary law, but this is a challenge we need to deal with. We had to deal very much in the case of Pinochet with customary law because there was not a precedent of indicting a former president on count of international crimes, but finally the House of Lords says, okay, we have not a president, but we need to give birth a president to have one day. And this finally happened. But also, the primacy of international law, including customary law, and the question of superior order, so the no exemption of due obedience defense, are in the Nuremberg principles. Go to the 7 principles. Everything is there.
Yeah, I mean, that question of customary international law in international crime trial processes, it's interesting because in South Africa, in dealing with this question of prosecuting a crime against humanity, what the apartheid government argued was in fact that South Africa didn't accede to the convention. And so in one of the first cases it went to the Constitutional Court around our chemical and biological warfare expert who was responsible for many of the massacres that were taking place. The court finally said that international customary law also enjoys primacy under the Constitution, and that has made it possible for us to indict. But I think a more, one of the most interesting questions is the one that talks about the whole question of command and superior responsibility. And, one of the challenges, I think, in many countries is the fact that often we're able to identify who the foot soldiers are, or who the particular police units are, or the military units who are responsible for crimes. But the much more difficult question is, how do we go to the people who gave them those orders? And how do we actually build what we call a link between the people at the top and the people who actually carry out orders? And that's the difference between what we would call a human rights investigation. And a lot of them happen. We have a lot of commissions of inquiry in the world who conduct human rights investigations. So we identify what the violation was, we identify who the victim was, and in some instances we also identify which particular perpetrator unit was responsible. But the more difficult question is saying, who is the commander? And can we actually show that there's a clear line of evidence which shows that the commander actually gave the orders? That's the first instance. The second is, of course, that they began to learn about the incident, and even though they had knowledge, they did nothing to actually stop that, or to, in fact, to hold those who carried out those orders responsible. So it's a crime both of omission, not doing something, and a crime of commission, which is you actually gave that. But establishing linkage evidence is where, in fact, when you look at most of the trials which take place across the world, where do they go? Down bend, it's around that question of linkage evidence. Give you an example. In one of the trials that took place of, one of these people in the DRC, where they were in fact committing massacres, there was an allegation that in fact there were 25 videos that in fact were scraped, collected, and they were put before the courts. The word 25 was used as a number. But when the evidence was actually handed in, there were only 24 videos. And you know what the court did? The court threw out the whole case. And so one of the most important issues now that we're beginning to deal with is no longer just talking about victims' evidence and perpetrators' evidence. You're talking about digital evidence and digital investigation skills. Where does most of our evidence come from these days? It's from scraping videos off the internet. But the way in which you do that, the way in which you preserve what we call the chain of custody, the way in which you make sure that it's collected, it's put away properly, it's tagged, and whoever collected it has given you the consent to use it, that chain of custody is crucial to the evidentiary questions that are going to come before the court. And so almost from the outset, we need to begin to look at, do our people have the skills to do that? And to be honest, across the world, this question of dealing with digital investigations and technology has become a very difficult issue, and everybody is grappling with this question of how do you collect, how do you preserve the chain of custody, and how do you ensure that contamination doesn't take place. Are prosecutors trained for that? To be frank, they're not. And that's where the training has to take place. But the other issue is this question of how do you make sure that somebody's not contaminated or tarnished by the fact that they were implicated in violations before? What the Kenyans did a few years ago is they brought judges from other countries and they said, let's do a vetting and screening of every single judge that we're going to put into the new judicial system. And you know how many judges were disqualified because of that? Because at some level they had been implicated in rights violations themselves or in corruption. Similarly with prosecutors. If a prosecutor is tainted in any way, it will definitely taint the investigation going forward. And so one of the things we talk about is how do you ensure vetting and screening process? Now that becomes an even more difficult question when you talk about the police, you talk about the military. And that is what security sector reform is about. It's about how do you clear out all the ones who may have a problem, and how do you look for younger ones who may not have been implicated in any of the violence. So in order to ensure this question of impartiality and efficacy, it's about skills, it's about vetting and screening, and it's about making sure they understand new terminology that we use, the collection and the preservation of evidence in a way that secures judicial and criminal accountability, whether it's now, whether it's 20 years down the line.
If I can add about the primacy of international criminal law, it is very important. The president of the former Yugoslavia tribunal, two young lawyers work with judges that are used to apply domestic law. They feel comfortable with domestic law. They are very reluctant to apply international law. But the Yugoslavia tribunal, the commission that drafted the statute of the tribunal, included international crimes that came from conventions ratified by Yugoslavia, international crimes conventional that had not been ratified by Yugoslavia, and also crimes from the customary law. And the Commission said very clearly, and later the tribunal confirmed it, that the binding character of international criminal law cannot depend of the diligence of the domestic authorities into domesticating international rules. If torture is a crime, it's a crime wherever the country has ratified or not the torture convention.
So we actually have many more questions, but unfortunately I don't think we can take more time. So I'm just going to say what the questions are, and then thank you both again, Carlos and Yasmin, for your responses. I hope you may have a few minutes afterwards to talk to people in the auditorium, and maybe you can come up to ask your questions. The questions we had left was, how do we address the issue of effective prosecution, given the need for skilled lawyers to prosecute complex cases involving mass atrocities? Another question was on how to ensure impartiality and efficacy of prosecuting crimes, and what kind of structural reforms to ensure judicial independence. Both of these are obviously burning questions for us, and I think we can continue the discussion with you on them. So I just want to thank you both very much for giving your time, particularly on the day you've arrived in Bangladesh. I know you're here for another week more. I hope people who are in the audience who want to speak with you more will come up afterwards and maybe try and see if they can make arrangements to hear from you in more depth over the next few days. And thank you all for being with us today. Just before I hand over to our chair for his closing remarks, please, after the program ends, there's some tea outside at the back of the room, outside the door. Please join us to continue the conversation there as well. Over to Dr. Shamsul Bari.
Thank you, Sarah. I wish I'd come earlier, because then I could have thanked Sarah for organizing this meeting. I recall that 2-3 months ago already, I'd been discussing with Sarah the situation in Bangladesh. Bangladesh, I was thinking of. But let me first thank our speakers today, and happy to be with you, because all four of us belong to the UN Human Rights Council. I was a special rapporteur for Somalia, and have been working for the UN for a long time in Geneva. I see you as my former colleagues. Thank you for coming. And আমার মনে হয় আজকের এই আলোচনাটা আরেকটু সময় নিয়ে যদি করা যেত, কারণ অনেক প্রশ্ন রয়ে গেছে। আমাদের বর্তমানে বাংলাদেশে যে পরিস্থিতিতে আমরা আছি, সেখানে এই প্রশ্নগুলো, আজকের যে আলোচনাগুলো হয়েছে, এগুলো ভীষণ জরুরি আলোচনা। এখনো সেই আলোচনাটা হতে পারে। আমরা যা করছি, ট্রানজিশনাল জাস্টিসের দৃষ্টিকোণ দিয়ে দেখলে আরো কিছু করার আছে কিনা, এখনো সেই সুযোগ আছে কিনা, এগুলো একটু আলোচনার জন্য আর একটু সময়ের প্রয়োজন। কিন্তু আমার মনে হয় না আর সময় নেওয়া যাবে। তো আমি এখানে ব্লাস্টের পক্ষ থেকে সবাইকে ধন্যবাদ জানিয়ে আজকের অনুষ্ঠান শেষ করছি। সারা বলেছে যে অনুষ্ঠানের পরেও আমাদের অতিথিরা কিছুক্ষণ আমাদের সময় দেবেন, তখন তাদের সঙ্গে আলাপ করার সুযোগ হবে। আপনারা অনেকে এখান থেকে হাত তুলেছিলেন, অনেকজন ভদ্রলোক ছিলেন, প্রশ্ন করেছেন কিনা জানি না। সেই প্রশ্নগুলো আমরা সরি যেটা আপনার প্রশ্নটা নেওয়া হয়নি, কিন্তু এখনো কিন্তু আলোচনার সময় আছে, এসে করব। কিন্তু এই যে প্রশ্ন যেগুলো উত্থাপন হয়েছে, ইস্যু যেগুলো এসছে, সেই ইস্যুগুলো যেন আমরা খেয়াল রেখে আমাদের এই যে ট্রানজিশন ফ্রম কনফ্লিক্ট টু কোএক্সিস্টেন্স, এই কথাটা বারবার মনে রাখতে হবে। আমরা কোএক্সিস্টেন্সের পথে যাচ্ছি কিনা, যাওয়ার জন্য আমাদের কি করতে হবে। আজকের আলোচনার মাধ্যমে আমরা অনেক রসদ পেয়েছি, ওগুলো বিবেচনা করে আমাদের ভাবতে হবে। সারা আমাদের মনে হয় লয়ার্স কমিউনিটি থেকে এই ইস্যুগুলো নিয়ে আরো গভীরভাবে আলোচনার প্রয়োজন আছে। I think Sarah will then explain to you what I was saying. Thank you very much, all of you.
Cover.